walked across the campus as he was deciding whether to accept the offer and join the faculty. And he is, of course, one of the foremost scholars and activists in America around issues of the death penalty. Wayne Reaud, the greatest client that not the great, one of the greatest clients, and friends and colleagues over the years. His incredible generosity to me, to the UNRO, the Human Rights Fellowship we all know, but through many struggles of which we were in which we were together, has contributed so much. Wayne Reaud was one of the 5 lawyers who won the historic tobacco judgment for the state of Texas. They did it all with their own money, would never have gotten a penny back for the millions they spent had they not been successful, and who devised a theory to bring the tobacco companies to heel, even though they'd won 800 cases in a row. Fernando Chávez, he'll tell a story. I can't even get through it. We had held a trial in Fresno in front of the jury. I think you better do the rest of it. I'm tearing up. Okay. Bernardine Dohrn needs no introduction, and therefore an activist, a scholar, founder of a wonderful program on representing youth at Northwestern University Law School. Robin Mardemootoo, who I met when I was teaching on the law faculty in Aix-en-Provence, which in the grand stage of marketing, they have named the Université Paul Cézanne, because a university named for Cézanne would be better. Robin then, from Mauritius, came to Texas, got an LLM here, amjured every course, and then began this long struggle of representing the Chagosian people who were kicked off their island in order to build the military base. So that's the game. All right? Can I?
Thank you, Michael. So I kept something from Michael, which is I didn't tell him how we were going to do the roundtable. That was great. And I'm going to stick with my first question anyway. And you'll get to hear some of the same thing from other sides. Now you have even longer bios, but they're not as, I think I should go over here. They're not nearly as passionate as Michael's, because people write them for themselves and won't say the kinds of things that he just said. It's really, one of the things about this project, I have to say, is not only working with Michael and getting to know his work so well, but is getting to meet and talk to people who have, who are his friends and colleagues, and learning about their work. And this roundtable is definitely an example of that. So it's just a real, real honor to have you all here, and it's just terrific to see you all sitting there after discussions about it and whatnot. So one of the things that you might have picked up but Michael didn't say is that all 5 of the participants are lawyers. And they're all lawyers who have been engaged in social justice struggles and human rights struggles. And we picked people who had known Michael from a variety of contexts. So client, colleague, co-counsel, and comrade, and also classroom student to keep the alliteration going, and wanted to hear from them about their experiences with Michael from these various perspectives. So we're going to start, and we're still going to do it with everyone. You can hear from them, so you can get a sense of everyone at the beginning, is to start with 30 seconds or 45 seconds on how they first met Michael, and maybe he made that a little bit easier for you. And we'll skip around a little bit, but let's start with Bernardine for this.
Okay, I met Michael in 1966. I was a third-year law student at the University of Chicago, and I went to California for the first time ever in my life, across the country, and met a bunch of people, and went to my first SDS meeting. And it was actually where SDS, Students for Democratic Society, voted to break the law and encourage draft resistance. So it was a tumultuous meeting, my first, and I just said nothing and watched. But I was introduced to Michael, if it was at both, but it was on the campus, don't know why. And I met Ken Cloak at the same time. And I'm just going to jump for a minute because we just met. We talked about he might be going to New York. I was considering going to New York to work for the National Lawyers Guild. He might go to work for the Emergency Civil Liberties Committee. This is what I think, but you're frowning, so the dates are wrong, or my memory is totally off. So what happened is that we both moved to New York City the same month, me graduating from law school, Michael and Michael Kennedy moving to New York from California to work at the ECLC. And we schemed and plotted about how to kind of divide up the military resistance, draft resistance, all of the mass demonstrations against the war in Vietnam.
All right, and if we go chronologically, the next person who would have encountered Michael was Fernando Chávez.
Thank you. Well, I was one of those individuals that was influenced to resist the threat. My dad was Cesar Chavez, and there was a strong influence of nonviolence in our family. A 19-year-old kid who had taken a semester off from school, didn't have a deferment, and I was drafted. I really didn't know what that meant. At 19, you really don't understand a lot of things. But I was counseled, and I soon learned that I was going to be subjected to probably a 4-year term for draft evasion in the San Joaquin Valley from a particular judge, Judge Crawford, who was a very conservative ex-FBI agent. And through a family friend, Jerry Cohen, I met Michael. And Michael agreed to take my case. And he litigated my case in Fresno, California, the hotbed of conservative politics. No more anti-agriculture, anti-farm worker than any place I can imagine in the country. And Michael spent a week trying the case in San Joaquin Valley under very difficult circumstances with a very honorary judge. Even then, at my age, at 19, don't know anything about law. The judge was honorary, and I could tell you. And this gentleman got me acquitted.
All right, and we'll get a chance to hear more about that. Wayne Reaud, when did you first meet Michael?
One of the problems when you're old is you can remember most everything. You just can't put it in a time. I've known Michael for a long time. I first learned of Michael Tigar as a result of a conversation I had with a very famous Texas lawyer who's a generation older than mine. His name was Joe Tannehill. Mr. Tannehill was an East Texas lawyer of considerable reputation.
Yeah.
And young lawyers like me, we were always interested in what Mr. Tannehill might teach us or tell us. And one day, I'm asking Joe, who is the greatest lawyer you've ever seen? And he told me that it was Edward Bennett Williams was the greatest lawyer he had ever seen. At that time, Edward Bennett Williams was considered by many to be the greatest lawyer in America. And before I can say anything, Mr. Tannehill goes, but Edward Bennett Williams says the best lawyer he's ever seen is Michael Tigar. And so I made up my mind then I was going to meet this Tigar fella. And when I finally did, we have a wonderful conversation. He is not what I expected. He was kind. His ego was not as big as I'd been told that it was. He was gracious. And it was a wonderful conversation. I'm about to leave, and he stops me and he says, Wayne, remember the Tigar first rule of practicing law. And I said, yes, sir, what's that? He said, if someone's going to go to jail, make damn sure it's not the lawyer. And that was great advice. I've never forgotten. I don't know if he remembers telling me that or not, but it was wonderful advice for me.
That was a way to get more business. Jordan Steiker.
So I met Michael in 1990. In the summer of 1990, I was looking for a law teaching position, and I had come down to Austin. And I'd been to a bunch of different schools where people asked me about my scholarly agenda and what, manuscripts I had. And Michael took me walking around campus and said, this is a place which really values lawyers and lawyering. So if you want to get involved in litigation and involved in social justice, this was the kind of place to come to. And he said, and an added benefit was that in Texas, there's a lot of injustice to address.
And that was part of why you came. Didn't want to be in New York where it was all different kind of injustice. So Robin, you're the young one here. When did you meet Mike?
I met Michael in 1994 in Aix-en-Provence, fortuitously. Somehow I was entitled to a prize by my law school, but they found out soon that that prize was only limited to European citizens. And I'm not a European citizen, so they felt really bad, and I didn't ask for anything. And a week later they said, we're trying to establish a relationship with UT, and there is a celebrity coming in a month, and would be delighted to introduce you to him and send you to Texas. That was not planned in my life, but then he came to Aix-en-Provence, and in typical fashion of Michael Tigar and the way he treats students and mentors them, he invited me to lunch to the best restaurant in town, and then the rest is history.
Great. So when in talking about Michael, it seems that a lot of people sort of have their set of words that they use to describe him. And invariably there's a discussion about what I would call style. So it's not about how he dresses, but it's about his way of lawyering, his way of connecting, his way of doing advocacy, his way of being in the world. And you've all experienced that in a variety of contexts. As I would also say, it would be a matter of a way of being as a teacher. And Michael, one of his ways of being is that he tells me when he wants to say something. No. Do you want to? Do you want to say something? Oh, okay. So I'd like to hear you all. This would be a way to kind of revisit, if you like, the stories that you started with, your first encounters, but also continue through various parts of your career and work. But basically, how would you describe Michael's style? We'll start with Fernando this time.
Well, you have to understand that I'm 19 years old. 1969. I'm scared shitless. I'm facing the real possibility of going to jail. I met Michael probably the week before trial, and he wanted to know about my conviction for nonviolence, and I started telling a story about I'd gone on a walk with my dad. I had like every other son and father, clashes. And is that unusual? To be any father. And but we went on this walk, and he started to tell me things that he had never told me before. Starting with nonviolence and what that really meant in terms of accomplishing social justice. And I was, even at 19, I was moved. It was very impactful because I had never had that kind of conversation with my dad. But since I was now faced with a great prospect of going to jail, I think he said, okay, I guess it's time to tell you what this is about. And it's been a long talk and a long walk, and it's almost 50 years, and I can remember every word. I can remember every step. I know where I was. And I can close my eyes and I can hear the background noise as if it was yesterday. So Michael starts to talk to me about my testimony and about nonviolence and what was it I started to recount what my dad had told me. And I got emotional because it was, even to this day, 50 years later, when I recounted this emotional event. And I started telling him, and he's listening, and about part of the way through, he tells me, no. That's it. But there's more. And he said, no, that's enough. The reason was that he didn't want it scripted. He wanted me to be able to sit there and tell the jury what he knew I was going to say. There was no mistakes to be made. I couldn't make a mistake if I wanted to, because it was real, it was from the heart, and it was genuine. And I understood much later the importance of that. And, you know, I do that all the time. I do that a lot. I have confidence with the client. I did that very recently, maybe a year and a half ago, on a wrongful death case with the daughters of a gentleman who passed who was killed. And it was very powerful because I think if I had gotten them to tell me the whole story, they would have gotten used to it. It wouldn't have been as impactful as it was when they told it for the first time. And I think Michael felt the same way when I was telling my story. So to describe him is he had a tremendous sense for judging human character, for judging human worth. And in the courtroom, he was very, you know, when you're 19, you see a lawyer and, you know, I was thinking about Perry Mason and, well, this guy's not like Perry Mason, but, you know, he's pretty cool. You have to understand that I'm 19. Michael, you weren't that much older. You were like 28. And I kept saying, God, this guy was really, really young. He was young. So it was something that had stayed with me all these years. And of course, I followed his career and I read about the cases. And it's something that has always stuck with me in terms of how he moved in the courtroom, where he moved in cross-examination, where he moved in direct. And it's so great now, you know, judges want you to use this thing here, you can't move around, and they want to rein you in because that's very impactful, the ability to be able to move around. So that's, you know, that's my perception when I was 19. And now that I'm older and I reflect back, it's much more powerful. And I was mentioning it earlier, a small group. There's two people in my life that were instrumental in me becoming a lawyer. One was my grandmother, who I loved dearly, and the other one, Michael.
Thank you for doing that, Michael. We have Fernando as a lawyer, and a very powerful. Bernardine, what was Michael's style? What would
Okay,
you
well,
say?
I'm going to tell a story that jumps a little bit, I think 7980, he'll know the date again. But he had, for reasons I don't know, leapt into the American Bar Association section of litigation, biggest, wealthiest section at that time, and was in line to become the head of the section of litigation. It's a one-year stint. You have to know what you want to do. Needless to say, I was at the time working at the public guardian's office in the city of Chicago, representing abused and neglected kids, doing class action litigation. It was no law library, a tiny room, a group of women, of course, and women lawyers. And so for some reason, he reached out, I don't know when we'd last seen each other, and asked me to come to a meeting of the section of litigation. I came, and a year later, he and Louise Lamothe started up what's now the Children's Rights Litigation section of the American Bar Association. But the story I want to tell is a little off, a little different than that, because I had never been to an American Bar Association meeting. I'd never been to one at a fancy resort. But I was told by everybody there that this was the first year that, it was the first year that half of the people appointed to be heads of committees were women, and almost half were people of color. And it meant that, among other things, people came with their children and their families for the first time ever. There was childcare for the first time ever. And so it was an entirely different cultural moment. And one of the things that Michael did, and I can't remember if it was, which year it was, but he recruited a group of African-American lawyers that year, I think, to go with him, litigators, to go with him to South Africa, and had set up a series of structured meetings about litigation skills with black African lawyers, and in anticipation of the transition that was rolling but not yet consummated about ending apartheid in South Africa. And that just struck me as something so, I don't know what, so brilliant and dashing. This is, remember, when the United States still considered the ANC a terrorist organization, listed as a terrorist organization. So it was that kind of the right thing to do, but also really brash and daring and with consequences, long-term consequences.
And doing it from inside, right? So,
And doing it,
I mean, I
this
couldn't,
case, from inside.
we couldn't possibly cover everything on the attempted biography, so I tried to touch on points I thought you all would, but obviously Michael's time at the chair of the litigation section of the ABA was very important, and it had this impact, but also most of your books are published by the ABA, and there's a real strong commitment there. So on one hand, you have, and I think you were going to say a little bit more about this, that sort of the working inside while also from the outside.
Yeah, one foot in both worlds.
And you also talked about the variety, sort of Michael's taking on clients and kind of how you think, sort of how you perceive the variety of clients that he took on.
Well, I use the word with you, fearless, I think, because I think that if you're a criminal defense lawyer, which several of you are, clients both come to you and you seek out areas where you think you can make an impact, and you don't exactly choose your clients, but in some ways you do by a lot of different methods. So to me, his clients represent a range, a wide political range for sure, but also we're not easy. We're not easy, and so it took him, I don't know what, wanting a good fight, wanting to put the state to the test of its power and how it was being used. One of the things he did inside the ABA that year was, set off a spark that encouraged more and more over that decade of ABA lawyers taking on death penalty cases, going south, big law firms taking on death penalty cases, coming down here. And I think, and working with local lawyers. So I think that he gave people a sense of do what's in your heart. This is what I saw in the ABA. And whether they were established, lawyers in partners in big law firms, or whether they were just coming up, he encouraged them. So, the simple idea of follow your heart.
Yeah. So, Wayne, Michael already talked a little bit about some of the work on the tobacco litigation, but I understand over the years, so lawyers often need lawyers, and you hired Michael on numerous occasions. And I wonder if you could say, why Michael? Why is he the person you turn to when you need a lawyer? And then maybe talk through some of the tobacco litigation as an example of some of the ways in which Michael's way of being made a difference.
Michael Tigar is no ordinary lawyer. Everyone here knows that, or you wouldn't be here. He's not even an ordinary great lawyer.
We need to hear this.
He's not even an ordinary great lawyer. I hired Michael Tigar every time I hired him because I was a lawyer and I had a way of exploring who was the best lawyer in the country, and Michael Tigar was it. I want you all to understand, please know this. Michael Tigar is the greatest living lawyer in America. I will try that issue against any lawyer in the country who thinks they've got a better candidate than mine. Tigar is wonderful. So whenever I was in trouble, when the federal government is after you, you don't sleep well at night. And I learned through the years when Michael Tigar was my lawyer that he gave me as much comfort as a man can have if the government's trying to put you in jail, especially if it's something you didn't do. You know, as a young lawyer, I believed in my country and in the greatness of America, and I thought if you hadn't done anything, you don't have to worry about it. I learned that that's not so. There's a death of innocence by many of us in this country who have seen the government's power overreach for whatever the reason. Michael Tigar has no peer. When Karen asked me, what is it that makes Michael Tigar, in your opinion, a great lawyer, she made me think. She's a pretty good cross-examiner. We talked for several hours. And I tried to figure that out. I just always knew Tigar was the best. First of all, his intellect is unbelievable. I don't know how well you all know Michael Tigar, but I'm telling you, he is so smart, it is truly scary. I've had a privileged life as a lawyer. I've had the burden and the pleasure of working with and against many of the greatest lawyers of my time. There is none like Tigar. His intellect is beyond compare, and you couple that intellect with the fact that he has great courage. Look at the people he's represented. Can you imagine what the FBI file would read on Michael? Many times at night I've wondered. I said, God, I'd love to see the Tigar FBI file. I imagine he's 3 foot tall, might fill this room. But Tigar had to be afraid. The power of the government, he had to be afraid. So it's not that he was fearless in my mind. It's the fact that he had the courage to wall up his fear. All sane men know fear. Michael Tigar is sane. He just had the courage to overcome his fear. He is not just my friend. He's not just a great lawyer. Michael Tigar is a great American. And I love Michael Tigar. I don't know if he really knows that. But when a guy, when you're walking through that valley and it's dark and you're lonely and some guy comes up to you and grabs you by the hand and walks with you, you never forget that. And I'll never forget Michael Tigar.
So, Robin, what was it like to be Michael's student? And then how did that translate into his co-counsel, collaborator?
Well, I join what my predecessors have said. In my humble view, Mike is simply a unique legal genius of a global dimension. And I don't say that lightly because, like today you can Google anything. Well, you can't Google the most complex legal questions, except if you're lucky to have Mike. Then you send him an email. And the answer you get, always, and I promise you, are just breathtakingly surprising, because he looks at things from an angle that nobody looks at things. Yes, I've been his student, but we've been working together for 18 years on the Chagos litigation, and we've made history in England. I remember when we first challenged, for the first time in English constitutional law history, an order in council. You know, an order in council in England is legislation by the Queen, and had never been reviewed. And we got it reviewed in 2006 for the first time. And when you undertake such challenges, you can't succeed if you are with ordinary lawyers or ordinarily great lawyers. You can only succeed when you've got geniuses behind you. And I remember we were consulting with Michael, even on British litigation, all the way here from Washington, D.C. And the threads he would be giving us would be just breathtaking. And 3 weeks ago, I was sitting in The Hague, International Court of Justice, Mauritius versus United Kingdom, and the Italian judge just asked us a question that has to do with, you know, bilateral dispute between Mauritius and England, and of course going to the jurisdiction of the ICJ, and that has been the UK's defense. And I immediately, in the break, first person I wanted to rack his brain off was Michael, and I said, tell me, what do you think about this? We need to answer this. And he's the one who would come with a reference to Jeremy Bentham, Blackstone, and Grotius. And you know, I mean, just simply extraordinary. Simply, you get a perspective from Michael that you cannot get anywhere else. And of course, now when you have him as a mentor, the things he inculcates in you. I'm a banking and corporate finance lawyer, but if today I spend half of my time doing pro bono international human rights litigation, it's because of him. I mean, he changes the lives of people without him knowing. I've never told him this, but international human rights had never been my thing. But we litigate in Africa for the Maasai people. We litigate in Sri Lanka. We litigate all over the world for the Chagos. And it's just because of him. All these pro bono litigation would not have existed if he had not spent time inculcating in his students a way to, to pay it forward. And that is Michael. I'm forever grateful.
So Jordan, Michael convinced you to come down here with Injustice, and then you started fighting a little bit of it together. And maybe you could talk about him as a colleague as well as a co-counsel on cases, and a teacher.
So it's kind of hard to capture exactly all of Michael's sort of charismatic aspects, but I think that when I think about what's unusual about him, I think it's the combination of this extraordinary erudition, that Robin just referenced, but a deep mastery of sort of the more prosaic aspects of law, but also sort of a groundedness in what's really important. It's kind of an odd combination of having the big picture view, the sort of all of the nuts and bolts, and then also really knowing what the heart of the matter is. And the way that I can sort of illustrate that, a couple cases that I worked with Michael on in the early 1990s were Texas death penalty cases. It was the worst time for death penalty lawyers in Texas, and the Texas statute that had been passed in the 1970s was deeply flawed. It didn't allow for jurors to consider much in the way of mitigating evidence. And there were two cases that Michael argued in the Supreme Court about two youthful offenders who really had no way of arguing that they should be spared on the basis of their youth. And we spent a lot of hours together preparing for that oral argument. Michael had a whole bunch of young lawyers where he would be cooking us dinner in his home and asking people to shoot questions at him. And it was a little bit of an unusual way to prepare for an oral argument, but it worked for him. And then I remember one of those oral arguments, and it sort of perfectly captured Michael's big picture view, mastery of detail, and groundedness. I remember that argument where, he said something sort of offhandedly about there was this ancient tradition of considering youth as mitigating and punishment. And Justice Scalia was skeptical, and he said, "What do you mean? How ancient?" And Michael starts talking about, 4th century Roman law and the institutes and how back then there was a clear understanding of the significance of youth as mitigating. But before he missed a beat, he said, "But you don't have to go back to the Justinian institutes to realize," and he said, the best way to illustrate this is my client's father, who said being 19 is a foolish age. And you do things when you're foolish that you wouldn't otherwise do, and everyone knows that. And it's just sort of the way that he could answer the question, which we certainly hadn't asked him about, how ancient the tradition goes, and then be able to move quickly to the more commonsensical, down-to-earth, realistic understanding that this is a powerful aspect of an offender that should really matter. And I've just seen that in all of my interactions with Michael. I mean, one minute you're talking about sort of the minutia of motions practice and writ practice, and the next thing you're getting references from literature and history and philosophy that are just a much bigger picture view, a bird's eye view of sort of what's at stake. And I think Michael never failed to see what was most important in the cases that he litigated. I mean, he had the mastery that most lawyers don't have of the law. He had, just the powerful voice and the powerful presence. But what he really had is he knew what was at stake, and he never, missed that. And I think that people were grateful for that. And I think that, from my perspective, that was the most important lesson that I took from him. And Michael's, I think one of the things he's always enjoyed in life is mentoring young lawyers and students, and it would give him energy to have young people around him, and I think he trained a whole cadre of tremendous lawyers during those years that he was at Texas.
Yeah, that was one of the motivations. Well, we should. That was one of the motivations of having the papers and making them available. And when I was saying, because how many law students are in here? How many students are in here? We're all students. Yeah, because we really wanted to create a resource where people could revisit a lot of times. I mean, it's just you've been thinking about a lot of things for a very long time, and you've written a lot about storytelling, for example, which we got to hear Fernando as an example, and to keep these alive is partly to continue the hope of that mentorship. But I'm just going to give you a microphone. Yes, please. You do, because we want it to be a part of the public record.
I'm glad there are law students here, because I think we get two messages from this, do we not? One is that people matter. That is to say, the law is not what it says, but what it does. And when Fernando talks about that trial, we stopped because I knew that he was going to tell this story about that walk with his dad. And there, as I stood at the end of the jury box, were people, the judge wouldn't take the growers' executives off the jury in Fresno, California. And the jurors were crying. They were sobbing it out. And then the next witness was your dad. And Cesar came in, and he took the stand, minuted, and he talked about that same meeting. And we couldn't go into the more general issues, but the prosecutor, William Allen was his name. He'd been an assistant U.S. attorney not very long. I think he used to try liquor store holdups in Bakersfield before he got that. I mean, really. And he thought he could take on Cesar Chavez. So he danced around a little bit, and then he asked the question. Mr. Chavez, you say you're a pacifist. Well, what would you do if a Russian soldier was raping your wife? And Cesar put his hands on the edge of the witness box and took a full 30 seconds. Then he leaned forward and said, excuse me, I've forgotten your name. And the prosecutor said, Allen, William Allen. Cesar said, Mr. Allen, let me tell you about the struggle of the farmers. And he started, and Allen jumped up and said, Your Honor, I object to this. I want to come to the bench. And that was the moment where I think when it turned. It had already started to turn when you talked. And we get to the bench, and Allen says, Your Honor, this Mr. Chavez is trying to turn this into a political trial. And Judge M.D. Crocker, the former FBI, just said, Mr. Allen, for 1 week now, I have kept Mr. Tigar from politicizing this case. But then you had to ask that damn fool question. So we are going to sit here until Mr. Chavez is finished answering it. And we came in the next morning, and the judge granted a Rule 29 and let us go home. 20 years later, I see Judge Crocker at a judicial conference. And I walked up and said, Judge, hi, Michael Tigar, remember me? He says, I remember you. You probably think you won that case. I said, well, I did. He said, no, you didn't. He said, that dumb son of a bitch lost it. So people matter. The story matters. Grower executives and this judge sitting there listening. That's question one. The other thing is about South Africa. We sat one night, Jim Ferguson and Ken Brown and I, in Cape Town, South Africa in 1989 with Dullah Omar, who was a Bernardine friend of Nelson Mandela's lawyer. And Dullah said, you're going to meet a bunch of young lawyers tomorrow. This is for all you lawyers. They're legal services lawyers and defenders and so on. And this summer, we're going to have sit-ins, wait-ins, lie-ins. We're going to bring the country to a halt with nonviolent demonstrations, but we're not going to plead anybody guilty. We're going to try these cases. So we want you to teach these young kids how to cross-examine cops. And we're going to get Mandela out. And I said, oh, yeah, sure you are. Yeah, I see anything. Well, you know, we did, and they did, and he did, and so on. So the two, see, look at this. Lawyering matters, and people matter. The law is not what it says, but what it does, and these are human stories. So I want to thank you all. Thank you.
You can hold on to it. You can hold on to it. So, does anybody want to respond to?
And Jordan, it was actually the 4th century before the Common Era, not the 4th century.
My mistake, I'm sure.
He was focused on the food. Just before we have one last question I want to ask everyone, but I wonder if anyone wanted to respond to anything else that was said. Yeah.
You know, Michael's absolutely right, and I learned this a long time ago. I do primarily civil, I don't do any criminal. But you've got a client, and the client has a story. The client has a story. There's always a story. There's a story to be told. It's just not facts and figures, but it's a story. How we got there, and what happened. And from the time I take the case, I'm looking at what's the story? What's my client's story? I have found that, all trials are about people. And yeah, the law is important and the facts are important, but boy, it's about people.
There's a lesson from Edward Bennett Williams, who told as a young lawyer staggering into the General Sessions Court under oath with a load of books before the days of Xerox to argue a motion. And one of the old courthouse habitué lawyers said, "Throw away those books, son. Get yourself a witness."
And you just ingested them instead. All right. Well, I think.
Can I just add one word here?
Please.
Because I think if you look at the list of cases, kind of famous cases that got a lot of media attention that Michael took, you see that, you know, he, for example, the Seattle conspiracy trial. This is one of the first of a range of, I don't know how many there were ultimately, conspiracy trials coming out of the Nixon administration in the face of powerful social movements, the civil rights movement, farm workers movement, movement of young people, you know, to kind of throw off the shackles, and in the beginning of the women's movement. And in that kind of framework of upheaval, certainly the Vietnam War at the epicenter of it, you know, these trials started happening. And Seattle had something called the Seattle Liberation Front. It was something like 20 organizations. It wasn't just a few guys. And you know, they were working in the community, organizing for community power, very grassroots-oriented kind of thing. And that was one of the first of the Nixon administration efforts to kind of go after, criminalize, and really stop the work by the uses of a criminal trial. And, you know, you can read about it. It was, you know, like the Chicago 7 trial, both a carnival by everybody being a caricature of themselves in a way, and but also of conspiracy. What is a conspiracy? Single count conspiracy trials. We all know that means no evidence, pretty much, right? So it is, you know, also easy to peel that off if you have a jury who can listen and will listen. So anyway, I just wanted to add that as a kind of an example where then there were conspiracy trials from all over the country.
But let me add what Jordan's talking about cooking and questions coming. Litigation is a team sport. That is to say, we talk about, well, Michael Tigar was in this case, Michael Tigar was in that case. One of the things that Lois Romano did, she did her profile about the Nichols case. You know, when I got appointed in that case, Ron Woods, who had been United States Attorney for the Southern District of Texas, had been an assistant United States Attorney, we'd been adversaries for a period of time. We worked together representing Senator Hutchison. We organized a team of lawyers that included UT law students that were working on it and a recent graduate, and combining the years, you know, our respective years of experience and approaches. I mean, I could do some kinds of witnesses. There's some kinds of cross-examinations, direct examinations I could do. We called 80 witnesses in the defense case. But Ron Woods, who left this law school, was an FBI agent and then a prosecutor and so on, brought this unique skill set and these unique organizational abilities. And I remember to this day beginning every cross-examination of FBI agents with, excuse me, sir, what makes you think you're qualified to be an FBI agent? Which is the greatest beginning for a cross-examination of one of those folks that I can think of. And I know Ron is here today, and you look him up, and he'll tell you more stories in the reception.
In fact, he will do so at the reception. So I want to end this part of the dialogue because we're going to get to have other opportunities to talk more informally too. But and this started in some ways talking to Bernardine and thinking about what lawyering was like in the 60s when she and Michael were starting their careers and against what, and feeling like times were pretty dark, but also a lot of excitement, right? And ingenuity and collaboration and thinking not just about the 4th century, but about how to change the world. And then I was struck when Jordan was talking about the death penalty in Texas in the 90s and that being an incredibly dark time. And so I wanted to ask, so obviously here we are in 2018, and I know it's a discussion that Lois will have with Michael a little bit later too, but what are I don't want to put it just in the terms of lessons learned from experiences that you all have talked about, although that certainly could be part of it. But basically, it's a question about what advice you might have for young human rights, social justice lawyers today. We've started that a little bit with about the need to tell a story, but maybe thinking about it particularly in these times. And I know Robin's in a slightly different context, but I understand our president has some impact beyond our country. So maybe we'll reverse the order a little bit, start with Jordan on this one.
Well, I'm not sure what broad wisdom there is from the work that Michael did then and that many people do now in the death penalty. I mean, I think that it really was a very difficult time, and I think Michael wasn't under any misapprehension about the chances for success. Most of the clients that Michael worked for got executed because these weren't trials. This was long after someone had been sentenced to death. I should have mentioned another case that I remember watching Michael argue about a guy who had been shackled before the jury in a death penalty case where the only question the jury was really going to ask was whether the person would be dangerous in the future. And I just remember Michael's, brought that issue, into such moral clarity. But it was, if I remember right, I think that was another case that was not successful. I mean, my sense of Michael's commitment was that he didn't think that lawyering was just about winning cases. I think part of it was about making a record and being a presence and taking a moral stand about the way things should be. And it was a bleak time. Some of the issues that Michael worked on have, the law has moved in the direction that Michael sought. Some of the issues he worked on, the law hasn't moved much at all, but I think that part of being a successful lawyer is not having success, but fighting battles that you're not likely to win, and maybe you'll prevail at some future point, but at least there's some tremendous value to having the commitment and energy of a skilled advocate to represent people who are, marginalized, despised, and really unable to represent themselves.
I'm so glad you said that, because I think maybe it's the lot of all defense counsel to lose regularly. But I think that question, I think about the Lynn Stewart case. I think about many cases that he did, and not one, not just your cases, but many of the great cases in history, and the Clarence Darrow, so I think that task of how you take it on to win, take it on to be to put zealous advocacy, the ethical obligation of zealous advocacy, to give it a shape and a content and a depth. So that I totally agree with what you said. I meant to bring up zealous and I meant to bring up losing before, because I think those are two parts of the lot of a lawyer, a defense lawyer particularly. And I don't know what that takes and how that works over time. I think it'll be in your archive. I look forward to seeing it.
Fernando wants to jump in.
Well, I can tell you as a young lawyer in the 80s, trying cases in the San Joaquin Valley, where the only brown faces in the jury room were myself and my client, with all white jurors. And if I was lucky to get a Hispanic, Latino, or a couple of blacks on the panel, once they got on there, boy, I fought to keep them on. They were off. And, I just kept thinking, Jesus Christ, am I doing something wrong here? I mean, I know I'm not a bad lawyer. I mean, I know this is a tough case, otherwise it would have been resolved. But I think it takes courage. It takes courage. And you've got to go in there and battle. Even to this day, I've tried a lot of trials, and I know when I walk through on the morning of trial and I put my briefcase down, my palms are sweating. I still have fear, but it's a different kind of fear. It's kind of an edgy fear. But there's got to be some courage. I know that you've got a client here. Do the best you can for your client, and you lose a lot, but it'll change. And part of the changing, for example, in the San Joaquin Valley and some of the other places I've tried cases in Arizona, is demographics are changing. I have a case that the jury's out now. Guess what? There's 12 jurors, 9 are Hispanic, and a Hispanic judge. So things have changed, and I think that you've got to be willing to get in the trenches. Fear's okay. Courageous. Be a tiger.
Yeah, I'm glad. I thought we did need to talk about losing, but we didn't want to end that way. So I'm glad there's also the changing demographics and a lot of other things that are taking place too, which maybe I think with all of it, there's there are things we can control and there are things we can't control, and sometimes they're helpful and sometimes they're not.
Can I say one
but-
other thing? Or
yeah.
I might take it, you can shut me down anytime. But especially to the law students who are here, because we're talking about the past, because we're old. But I wanted to talk about right now, because I think the challenge for law students in particular is to put yourself, where the action is. To find both a lawyer that you want to study with, be mentored by, but also to go to where people are making the breakthroughs. And I think right now, and I feel way too much nostalgia for the 60s in particular, in a certain crowds and certain sectors, because there's so much happening today. So, if to the extent that you can, put yourself with, the undocumented and unafraid young people. Put yourself with Black Lives Matter. Put yourself with the people struggling for climate change, the people who are up at Standing Rock, the people who, you can go on and on and on, but every day's news will give you lots of examples of, standing by women's dignity and women's rights and standing for gay and lesbian people. And I just think that it's a look around. So there's plenty to do. And if you put yourself there, your clients will teach you, as you said so powerfully and Michael said about you, and also you will be changed. That's the beauty of it.
Okay, yes, sorry. As far as, tonight you talk about the sweaty palms. Ron, remember as we would go through security, where's Ron? Woods? Oh, there. Every morning we would go through security and we'd turn right and walk down towards the courtroom, and as we passed the men's room, what would we say to each other? Yes, time to go throw up. So that was that. And the other person, what's happened in legal education here at this law school and in others is that exactly this kind of involvement is happening in clinical programs. And the clinical program that worked on the Chagos case all those years was funded by none other than the lawyers who had represented Texas in the tobacco litigation, who saw that that was the way that the work was going to be carried forward. So, once again, that's another contribution that Wayne Reaud has made to the way the profession organizes itself to get this done.
Great.
I think maybe 30 law students in here. I sort of counted hands quickly. There's something that you need to know, and that is fear is always in the courtroom. When you hear great lawyers like Mr. Tiger, Mr. Woods, talk about how they want to go throw up, that is a common statement from trial lawyers about to pick a jury when the trial's about to start. I was a young lawyer for about 3 years, had the privilege to work for a great lawyer, and because he was a great lawyer, he was in court all the time, and I was carrying his books. And one day, I said, Mr. Mayor, how long do you have to do this before you stop being afraid? And he looked at me like I was stupid, and and he said, son, you better hope you never stop being afraid. That fear is your fuel. That fear gives you an edge. And so as a young lawyer, if you think, oh, Lord, I can't try a case, I'm afraid, just go forward. You're like everybody else. If you think about a trial, the defendant's afraid. He's afraid he's going to go to jail. The plaintiff's afraid. He's afraid he's going to lose. The plaintiff lawyer's afraid. He's afraid the jury won't believe him and won't like him. The jury's afraid. They've probably never done it before. Everyone in the courtroom is afraid. Fear is always in the courtroom. Be a tiger and get rid of
Now we have fear and we have losing on the table, and a lot of courage. Robin, you want to weigh in?
Sure.
Have the final word on this?
So we are in 2008. Lord Hoffman in the House of Lords just asked a question. And he said, well, okay, we all agree that Chagossians need to go back to their islands, but there is a feasibility study on the records which says it's not feasible to send them back. The water is rising, climate change, so why are we even sitting here? So we said, we didn't see all the volumes of the feasibility study. It was in 5 volumes, and we've only seen 2. And the government lawyer says, well, because we've lost the 3 of them, so only 2 were available. So this is the government outreach, and today the problem's still the same. Well, and Lord Hoffman relies on that feasibility study to deny us the right to go back there because it was no longer feasible. Well, guess what? 3 months later, by total mistake, the government lawyers, which have changed, the new team of government lawyers in another case, sent us the missing 3 volumes by mistake. And so the first thing I did, as usual, sent an email to Mike, and I said, well, guess what? Richard Gifford just informed all of us, we've got the 3 missing volumes. What do? English constitutional history, never has a House of Lords decision been revisited. Never. So the first thing Mike said was, no, we need to go back. Irrespective of whether we had precedent or not, we need to go back. And he came up with a very old common law principle called the duty of candor, that the British government's lawyers lacked and failed the duty of candor. And believe it or not, the House of Lords accepted to revisit the judgment for the first time in British history. And but before we re-argued the case, the British government was smart and commissioned a new feasibility study which declared feasible the resettlement. So we won as a result of us, led by Mike, to insist on a matter of principle. Even though there were no precedent in England, he wanted us to revisit, and the House of Lords did.
Great.
So we can add candor to the table, too. So before you join me in thanking this incredible roundtable, I just want to make sure and get to the reception on time. So we're going to take a 5-minute bio break. And that's no refreshments or anything, just people who need to run out can run out and come back in. I'm not going to introduce Roger and Neville, beyond what I already have said. When you come in, they'll be set up and ready to do the reading. You can read about them on the break. And then we'll go to the interviews. So, see you back here in 5 minutes, but the first 30 seconds of that has to be thanking this incredible.